But you can't in the one breath say, if a state imposes a tax on production, it's an excise, but a royalty on production is a tax on mineral rights. That was the little mismatch. And that is why in that sentence they say, previous para in this, that therefore a tax is not a royalty. But what was the view which they accepted, Manoj? The Mysore judgment said royalty is an exaction. And that clearly is, and I'm going to show my lot of the provisions. Royalty is an exaction, and it has become more so, if I may say so with respect, Manoj, after the 2015 amendments. The auction rules and this and that, how the whole MMDR Act now works after your Lordship's judgment in the coal matters and all saying, please, these are national resources. Their mode of disposal has to be completely transparent and maximum revenue for the state. Now, when you make a law for maximum revenue from the state and the state auctions and gets as much as it can out of this resource, and which is not what is good because that money is going to go back into the coffers of public good. And then you say now you can ramp it up more through mineral rights. It's not going to work because there is a limitation. Private rights, yes, please tax them. Your own public rights. When there is an elaborate mechanism created for you to harness these rights, you cannot go beyond. That is really the principle. So that was the Mysore test. That was the Patna test. This is an exaction already. In that sense, royalty is akin to a tax. Now that becomes, my lord, the shorthand becomes royalty is a tax. And the moment you say royalty is a tax, you say, hold on a minute. Royalty is the price of the mineral, is not a tax. And then you say, oh, somebody got it really wrong. But if you look at it this way in its larger context, that royalty is an exaction by the state in respect of its mineral wealth. And when Parliament has come up with a complete code on how that wealth is to be harnessed, is that not a limitation on the tax on mineral rights? That's the real issue. Lordship can say yes, your Lordship can say no, but let's at least be clear. That's the issue.
Mr. Salve, you talked about mineral wealth and how it is unevenly distributed all across various states in the country.
Yes.
You also talked about perhaps hinting at the generational exploitation aspect, meaning thereby the limitation on the exploitation of mineral wealth. If this generation exhausts, extract the entire thing, a particular state is going about whatever is available, extracts. To put a cap on the quantum, we talked about only the price element. To put a cap on the quantum, that could be a limitation.
Also
pertaining to mineral rights.
Entry 23. That
Entry 23. Of course, you have said it in your opening. You cannot denude the right of the state.
You are not denuding. As I said, the trouble is, we try to fit this in a pigeonhole. 50 stands by itself. Denudation, occupied field, and repugnancy. There are three well-known constitutional concepts. But we should not try and squeeze 50 into any one of these. It can be a different kind. There is no, as my Lord the Chief Justice pointed out, there is no other entry like this, subject to limitations imposed by Parliament. This entry stands on its own. So, my Lord, to say that therefore this is a kind of denudation, why do we need to put a label on it? This is not a denudation. You have the power. My Lord, tomorrow, if there is a private lease and if you're going to decentralize or denationalize minor minerals, the power comes back in its plenitude if you take it out of the MMDR. So, that power is not taken away. It's a specific, pinpointed limitation by Parliament. What I am saying, and the only point of difference really is, I say when the phrase is by a law relating to mineral development, anything which is integral to mineral development becomes a cap on a taxing power. Why? Because the Constitution says. So no use going back to Sundarabaya. Sundarabaya was not dealing with an entry like this. In fact, again, respectfully borrowing from what the attorney said, this is a peculiar family, mineral rights, and it has its history. It is rooted in history, and it is not perhaps instructive, and it will be of assistance to your lordships to see that history. How did this evolve? The legislative history of this matter starts with the Government of India Act. If land includes minerals, as I indicated yesterday, there are two arguments which your lordship will have to consider. One is the pure legislative argument saying if there is a specific tax on a species of land, can you also read it into another engine, which is not subject to limitations? That's one thing which which is wrong with Murthy's job. But the second is also wrong, Malad. Post 1950, in any event, after the entire Zamindari abolition happened, invariably, in all the land reform laws, mineral rights were given to the state. Now, if I do not have the right to a mineral, how can it be taxed? How can the value of the mineral be a legitimate measure for taxing me on land? If you have a tax on vehicles and I don't own a car, can you say the annual value of the value of a car will be the tax you pay on a scooter? That won't be a legitimate measure. The way Murthy looked at it is, mineral rights are only a measure. You can't have a measure unrelated to the subject of the tax. Now, if mineral rights are part, one can understand saying, okay, I'm taxing a part of the land. But if mineral rights are not there, they can't be a measure. And that is why, Manoj, because by the time our Constitution, 35 Act itself, started making these differences, because by which time a lot of the mineral wealth, partly, Manoj, as your Lordship will find in the judgment, because when the British started granting zamindari, and World War I, World War II times, they realized we need coal. I mean, the war machine needed coal. They needed iron ore. So they started taking the mineral rights away. So 35 Act recast this completely.
Section 9, which provides for royalty rates or cap, is an exaction which has been imposed.
It's an exaction. And tax on mineral right is also an exaction, albeit in the form of a tax. The difference on tax on mineral rights and royalty will be, and I made bold to say so, where the state is not the owner of the mineral. And we still have some small areas where some minor minerals don't belong to the state. The state has nothing to do with the minor mineral or the mineral. Mr. A private person, is exploiting the mineral. He's not even giving a lease. He's digging up his own ground and taking out mineral. You can say, all right, I will tax you on this, on your exercising your mineral rights to extent. Or A gives the lease to B. As we have so many cases, one are decided by your lordships, decided by high courts. State can say, I'm not exacting anything, I'm imposing a tax on mineral rights. Now, where the state itself is the owner of the resource vested in it for public good. We have now long abandoned the theory that the state is like any private owner. That ship sailed long ago. Your lordships in RNRL and Reliance went to the extent and say these are all these, the mineral wealth is held in trust. And that is why these elaborate provisions. And once your lordships see, the current trend of the legislation on how auctions are held, how prices are fixed, it's a complete fit. Now,
Mr. Salve, you're saying where the state is the owner of a resource,
owner of the mineral,
vested for public good.
Vested for public good, it is all, royalty itself becomes the exaction. And if you say no more than this, then you can't sidestep that. Then that itself is the limitation. And this is never going to happen to major minerals, but maybe in minor minerals, we have seen some of the minor minerals are decontrolled. The state says, all right, you let the private people deal with them. The moment that happens, the legal character changes. And Parliament may not want to limit that. If Parliament says no more than this much tax, then public or private, that tax is frozen. Because, my lord, please see what a question which my lords have asked 3 times, and the answer lies in the question. It has to be as a facet of mineral development. The limitation must not be, I don't like your face. I don't want you to burden poor industrials. It has to be as a facet of mineral development. That's very important. That's in 50 itself. You can't generally limit as a resource limitation. It has to come as an integral part of a law which limits mineral development. How will that come? If it was, my lord, a general, in fact, as my lord the Chief Justice pointed out, some entry says subject to a law made by Parliament. Not any kind of law. Parliament can make any law and knock you out. But, my lord, when 50 says by law relating to mineral development, that means the limitation must be an integral aspect of mineral development. So when we see all this,
yes,
that is how your lordships will have to look at it. So, my lord, to get to this, and that is what, my lord, how our submissions are treated in your lordship's judgment is another matter. It's put in 2 sentences in India Cements. You cannot do indirectly increase royalty. This was the submission. And the submission, my lord, actually, since I have only less time today, let me just digress a little. The submission about the contradiction, as I said yesterday, my lord, had nothing to do. The judgment is dealing with two completely different points. Justice Vanchu's dissent in Ingrid, and I'm going to read that to you. The majority, say so in all humility, my lord, was clearly right. They said a tax on mineral produced, the quantity of mineral produced is the measure, the taxes on mineral rights. He said no, the moment you put it with reference to mineral produce, it becomes an excise duty. So it's unconstitutional. And the next sentence he says that royalty can be a tax on mineral rights. But royalty itself is with reference to mineral produced. What it was saying is, if that is so, then royalty is not a tax on mineral rights. If something with reference to mineral produce is an excise duty, it doesn't metamorphosize when you call it royalty. I mean, it's either excise, it's wrong to say it's excise. With great respect, the majority didn't accept that. And nobody has ever even ventured that line of reasoning ever.